Morning.
Good morning, Judge.
Morning.
Good morning, Your Honor.
Morning. Ms. Irena.
Good morning. Is my audio okay?
Yes.
Great.
Can you all
Thanks.
hear me?
Yes.
Yes, sir.
Okay. Ms. Balovich, I know Mr. Gonzalez, I know his position. Mr. Irena, are you a witness or are you?
Your Honor, I'm co-counsel with Ms. Belovich.
Okay. Edith Figueroa?
She's my paralegal, Your Honor.
He's your paralegal. Okay.
Yeah.
Are we expecting anybody else?
No.
Okay. We're here on a motion to, Mr. Gonzalez filed for a default judgment. An objection was entered and we're hearing on an objection, correct?
That's correct, Your Honor.
Okay. Ms. Balovich, it's your motion if you want to go ahead.
Yes, Your Honor. As the court knows, for a default judgment, the court has to apply strict scrutiny to the service rules. In this case, he attempted default judgment by substitute service. And those rules are set out by 501.2 subsection E. The affidavit and evidence on file with this court does not show, first of all, that any attempt at personal service or mailing was made on Isabel Silva before the motion for default judgment was filed. That's the first requirement. So it should be just denied on that ground. Even had he done that, the service that they authorized in this case is belied by his own affidavit. His own affidavit says that Isabel Silva is on the run. He's not at the marital homestead. And the subservice he requested was service at the marital homestead when Mr. Olivas testified under oath that Mr. Silva is not there.
Your Honor, if I may, I don't think Ms. Blagovich has any standing to complain here. The rules are very clear. It's longstanding rules that even if I take a default judgment against one person, it doesn't matter if they're married, if it's a joint and several liability pled. Me taking a judgment against another party does zero to affect the rights of the party that is before the court. So she has no standing.
I'm going to allow Ms. Balovich to continue, and you can bring that up in your argument. Go ahead, Ms.
Yes.
Balovich.
Okay, and I'm not sure what rules he's referring to, but certainly I have a response to that. So again, if you look at the alternate service rules, he was required to attempt service personally or by mail before he asked this court for permission to do alternate service. That was not done. Second, the court can do alternate service on a place where the defendant can probably be found. The problem is Mr. Olivas testifies under oath in his affidavit that Isabel Silva is on the run and is not at the marital homestead. So he knows full well that service by posting at the door is not likely to affect service there. The second attempt request that he made was by email. That was not done. There was no return of service by email, and that was the alternate authorization. In addition, he can't just put an email address out there without explaining some evidence that that's an email address that Mr. Silva has checked. The case law on that is typically proof that the person has responded to that email address with characteristics that indicate they're the person actually serving it. None of that was done. And so because the grounds for alternate service haven't been granted, we're asking the default judgment be denied. Beyond that, we obviously have challenges to the substantive complaints here. We don't think that the contract shows that they're entitled to damages for the failure to renew the annual fee. The contract on its face says the remedy is forfeiture of the bond or of the person who's on the run. That's his remedy, not to require him to pay an annual fee every year.
Okay, Mr. Gonzalez.
Your Honor, before I understand what Ms. Blagovich is saying, but the very first thing to consider is whether she's got standing to complain. Quite frankly, unless she's representing the defendant, Isabel Sanchez, she can't be acting as his lawyer. And to the extent that she wants to act as his lawyer, then she needs to make an entry of appearance and act as his lawyer, maybe a special appearance, but she needs to have authority to represent him. She's got none. And she hasn't given any testimony as to why she would be entitled to represent him. Second, her own motion says that she's got this standing by this nebulous construct that because they're co-defendants, that therefore it's her client who's complaining. Well, her client isn't a lawyer. Her client isn't authorized to represent the co-defendant. There's no testimony to that. And this lawyer has taken it upon herself now to represent a guy who's under 20 indictments or so for sexual assault of a child and on the run. She just simply cannot complain. Her complaint is that, well, if you get a judgment against him, it might affect us. The rules, the law in Texas is very clear. If I take a default judgment, a co-defendant, even if I plead it as joint and several, it does nothing to the defendant that's before the court. That one's going to stand on his own. And saying, well, they're married. Well, that has nothing to do with it. She still needs to have standing to represent him and has none. Again, Judge, it is an argument that's really just smoke and mirrors. Additionally, we did ask the court for substitute service that the court granted. She certainly didn't oppose it. She certainly didn't do anything about it. And the reason she won't come and make an entry of appearance, because then she has to be aiding and abetting the flight of a felon. And I know she doesn't want to do that, but that's where we're at, Your Honor.
Do you have any case law when your argument, you say that the case, it's clear, it doesn't affect the co-defendant?
Yes, Judge, I'll have to log into the other computer to get it. Let me see if I can just. Let me see if I can.
Just from a practical sense, I could see, if they're jointly and severally liable, if one pays, it lessens the load on the other one. I can understand that argument.
Right, and so if we get a judgment against, that's exactly right, but it doesn't make her personally liable in this lawsuit if I get a judgment against him.
Ms. Balovich, do you want to respond while we're waiting?
A couple of things. One, Your Honor, I think Mr. Gonzalez has not shown alternate service. And that's something, whether I point out or an attorney ad litem on publication points out, Mr. Gonzalez has failed to point out anywhere in the record that alternate service can be granted. If he's coming in here and saying, I can just get a default judgment without following the rules of procedure, Your Honor, and nobody's here to challenge it, that's very problematic. As far as the standing issue goes, I don't know what case law he's referring to. There's multiple reasons why this impacts my client. A, economically, they're married. Anything that's used to satisfy the judgment is her property. It's joint and several. It runs the risk of inconsistent judgments, Your Honor. I mean, we have a challenge to the substantive basis for this contractual suit. We've raised a substantive basis to this contractual suit. If you can grant a default judgment on one, then you have a potential inconsistent judgment on the other. Third, he can't get a final judgment in this case without both parties' cases being resolved, and my client has a counterclaim on file. So I think what you hear is that there's not great grounds for a default judgment. Mr. Gonzalez has not pointed out that he has.
Your Honor, again, we're putting the cart before the horse. She has no standing to represent this defendant, zero. And again, if she's doing it, all she's got to say is I'm representing him, and I will withdraw my objection to that. But she's not saying that because she doesn't want to aid and abet a felon. Second, and very important here, if I got a judgment against him, she's right, it's interlocutory. Now, it would stop being interlocutory if I severed the case out and let a judgment stand against the defendant on his own, then that defendant affects only him. It has nothing to do with the defendant she claims to represent in this proceeding. So yes, there is a procedure. And because she thinks that at some point in the future, there may or may not be an inconsistent judgment, then that has nothing to do with the fact that taking a judgment against a defaulted defendant will not affect her. And again, she's got zero standing to complain. And if there's a problem, well, you know what, Mr. Isabel Chavez, whatever his name is, can raise it on appeal. Because if it is a void judgment, you can raise it for the first time on appeal. And that's where we're at. I mean, she can't both be the lawyer and not be the lawyer at the same time.
Let's look at the alternate service, and I'm going to share the screen. Hold on. Okay, so Ms. Balovich, this is what you're referring to here for alternative service, correct?
Yes, Your Honor.
Okay, Mr. Gonzalez, how do Ms. Balovich saying there was no prior attempt to make service? What is your,
Your Honor, we have filed an affidavit showing the court why there is that it would be impossible to serve him at that house. And there's an affidavit attached to that. And the court granted the alternate service.
I understand, but was it rightfully granted is what I'm getting at. I mean, if you look at the rule, let me go back to this. Hold on. It's methods under B are insufficient to serve the defendant under B, and B is
Right?
service. So you at least have to make an attempt, correct?
Let me see, Judge. It's so small. Let me see.
I'm going to go back down to E, which is alternative service. It says if methods under B are insufficient to serve the defendant, which implies that you have to at least try B first.
Well, Your Honor, I don't read it that way. I read B as saying in other words, it doesn't make you engage in an exercise in futility, and that would be a consistent reading of the law. There's no case that's been offered by Ms. Blagovich to suggest that you actually have to go through a meaningless exercise before you can ask for alternate service, because you're saying, look, this is the way you get regular service. But if those ways are insufficient, then you can do it this way. And we, in the affidavit, it sets out that that would be impossible, and you couldn't get it done. And then the court granted properly the alternate service.
Your Honor, I think that, may I
Sure.
respond? Your Honor, I think that what Mr. Gonzalez is trying to do is evade service by publication. What the rules say is that if you can't do service personally or by mail and by alternate service, you can do publication in JP court, but then you have to follow the county and district court rules. And the deal with that is he's going to have an attorney ad litem who's going to do the exact same thing that I'm doing, which is making sure due process was followed.
Well, I would point out that Ms. Blagovich is not an attorney ad litem. And again, if all she says is I represent Mr. Silva, Isabel Silva, that's all she's got to say. And that eliminates the problem. Ms. Blagovich, do you represent Isabel Silva?
She hasn't entered appearance, so I'm going to take that as a no. Defendant, here's your affidavit.
Right.
He appears to have left the marital home, even though his wife, Lizette K. Silva, continues to reside there.
Right.
Warner East End. Okay, well, I mean, you know, the rule is that they do have to make an attempt. I think it's written in the statute. And then Mrs. Balovich's next point of argument is, here's this under oath. I believe the post and citation petition for order for service 400 serve anybody over 60 years would be effective. On what basis is that belief held?
Well, the belief is on the fact that that is the marital home and that's where the wife lives. And presumably they're in contact. But, you know, if you can get it to the wife, that's better knowledge than if I go and put it in some newspaper someplace that she's unlikely to read. And so this is at least as likely or more so. And that's why this was done in an effort to make sure he understood that he was getting sued as well. And I suspect that that's why the court said, yeah, that's more likely than putting it in, you know, in some newspaper that he's never going to read.
Ms. Balovich?
I don't think those facts are shown here. If you look at paragraph 3, Isabel V. Silva is currently on the run from law enforcement after he has been indicted on a 25-count indictment for possession. requiring him to post a $375,000 bond. He appears to have left the marital home, even though his wife, Lizette Silva, continued to reside there. If he wants to put forth evidence that my client is in communication with Mr. Silva, or then put it forth, but he has not done so here. He says he's on the run, he's left the marital home, she's resided there. There are no facts that show she's in communication with him. The contrary is indicated here.
Well, I think that would be up to Ms. Blagovich to prove up by representing Mr. Silva or by filing a special appearance. That's just not the case. The fact is, we know where he lives. We know that's his residence. We know that's his marital home. He's on the run. So, I mean, are we going to publish in the New York Times? Who knows? But it's more likely that he's going to get some inkling that he's been sued by getting it to Lizette Silva, which happened here, than it is to put it in some newspaper out in the middle of nowhere. And Ms. Blagovich, again, she keeps skipping over the fact she's got no standing to even complain about this. Zero, unless she wants to be aiding and abetting the felon, Mr. Silva.
Okay. I think this statement that is likely to be, I believe the postal citation, that needs to be fleshed out. Why is that belief held? And is it a reasonable and substantiated belief? And I think probably when I first read this or granted it, I was acting probably under the assumption that they were in communication. But, it'd be facts like how long has he been on the run? Other instances of communication. Something would have to be to substantiate this number 5. And now that it's in question, I need that substantiation of that information.
Well, Your Honor, can I get from the court whether or not can I get a ruling on whether or not Ms. Blagovich has standing to bring this matter up? I mean, independent of what the court decides, I need the court to rule on whether Ms. Blagovich has standing to complain.
Well, okay, you're wanting the court that she has standing. Okay, the first issue is whether the alternate service was properly granted. And now I am questioning that. So why does she have to have standing to raise that?
Because she's the person raising it and she filed a pleading. And so because there's a pleading, there's actually a live pleading in this court, we need the answer whether she's got standing, right? And if she does, the next question is she acting, if she has standing, is she the attorney for Mr. Silva? Because if she is, then my next motion for substitute service is to go serve her.
Ms. Blagovich, do you want to respond?
Mr. Gonzalez has yet to provide the court with the authority that he says is on his computer that says I can't raise this, first of all.
Because I'm on this one and I have to get to the other one.
Second of all,
I can pull it up here and I can't.
Second of all, this court has its own authority, especially now that it's been brought to the court's attention, to look at a judgment to make sure that it's been granted. You don't have to rule on my standing. You see the defects in what's going on.
I mean, if it's a matter of service, of substitute service, alternative service, I mean, I think I have reserve the right to look at that at any point in time.
I understand you do have that right, Judge. And like I say, independent of that, she's got a live pleading where she purports to be acting on behalf of Isabel Silva. And so I'm asking the court to make a finding on whether she's got standing or not. And as we move forward to this, because what's going to happen is I guarantee you there'll be another pleading where she's going to claim to be acting on behalf of her client, but really representing the felon on the run, right? The accused felon, let me just put it that way. And it's going to continue happening throughout this whole process, Judge. And so,
see, you sued, let me see, Lizette Silva, which she's entered an appearance on her. So she's an attorney of record for one of the defendants.
Right.
At that point in time, if she's acting, we'll take it up then. But as of right now, I'm not going to rule on that. So that's where I stand. I mean, if you want alternative service, you're gonna have to bring another motion for alternative service. And if it's to serve the wife, we're gonna have to flesh out, why there's a belief that would, in all reasonable probability, provide notice to him. And that's my ruling.
May I raise the second motion that's filed before this court, Your Honor?
Sure.
I filed a motion for expedited discovery. After, I don't know if it was after this hearing was set, Mr. Gonzalez's client sent my client a letter that instructed her to tell her lawyers to dismiss this case because she was contractually required to indemnify him for all causes of action in this case. That is not shown in the contract that was filed with this court. And so I sent a letter to Mr. Gonzalez, which is attached to my motion, that asked him for a copy of that document. He didn't respond. And so I filed a motion for expedited discovery, which is fairly limited. And I'm simply asking for a copy of any contractual documents between his client and my client that would support the threat that he made to my client in that letter.
Mr. Gonzalez?
Your Honor, if we're going to engage in discovery, I will ask Ms. Blagovich to make her client available for deposition.
Well, I mean, you certainly can. I don't know that it'd be granted, but you certainly can.
Right. And so that, I mean, I think discovery, what's good for the goose in justice court is good for the gander, Judge.
I agree. I regularly grant it.
Okay. Well, then I would ask the court to at this time or issue orders allowing for discovery, including depositions and requests for production from the parties, and then we can answer those things.
You can file a motion. I mean, the rules require you to file a motion, but generally my policy is to grant discovery, particularly when there's lawyers involved. And there's lawyers on both sides. I have no problem with discovery on either side, generally, unless it's just something bounds.
Right. Great, Judge. Then I'm making an oral motion to that effect.
We got to commit it to writing, and we'll get it taken care of. But if you file a motion, we can certainly consider that, and in all likelihood, it'll probably be granted. How about in regard to Mrs. Balovich's current motion right now, though?
Well, I'm imagining that her client should have those documents. I don't have that document with me. I know that typically there are indemnity agreements, but certainly if Ms. Blagovich's client doesn't keep a set of her documents, that's not my fault. But, I would just imagine that I would, let the court decide on those issues, to what extent the court is going to authorize any kind of discovery.
So it's asking any documents in your possession that constitute a contract or evidence of contractual agreement between plaintiff and defendant. Is that case of that sounds reasonable? So yeah, I would grant that. Is it a matter of time? Or we have any settings in this? Is that what the problem is?
No, Your Honor, it was simply, I filed it simply because I knew we were going to have a hearing today, and I thought it was expeditious just to resolve all matters. I did attempt to confirm with Mr. Gonzalez before I filed the motion. I asked him to send it to me voluntarily. He didn't respond. That's why I filed the motion.
Okay, Mr. Gonzalez.
No, Your Honor, we had asked to continue this matter, and of course that didn't happen. So I guess I'm going to ask the court again to continue these matters to a date where we can have all our discovery done, I guess, and then go forward. So I can now I'm going to have to serve Mr. Isabel Silva some other way. So yeah, I'm going to ask for more time, Judge, before we.
Time for what? We don't. I'm looking. I'm not aware of any settings. Is there a setting? I don't see,
We had,
unless I'm missing something.
well, we had asked for continuance of today's setting, Judge.
But this was on,
Today's hearing?
yes, but
Right.
this was a motion hearing, Judge. It didn't require any evidence.
Well,
It was a mo-
well,
It was a motion for
Yep.
default judgment. A motion for default judgment rises and falls on the service issue that's of record.
Okay, Ms.
well,
I don't understand. What were you asking to be continued?
I was asking anything that was happening today to be continued. That was
Why
my
didn't you
first
express that
motion.
when we started off in the hearing?
Well, Your Honor, I asked that. It's on file, and Ms. Blagovich didn't communicate with me, didn't agree. She basically said, I will not agree to this. And then proceeded. Now she's complaining that I'm not communicating with her. Courtesy
Your Honor.
would dictate that she would agree to that continuance. She didn't.
Your Honor, may I respond, please?
Sure.
First of all, I've listened to my name be bludgeoned for about 27 minutes. My last name is Balovich. It's pronounced just like it sounds. There's no G in it. Please try to pronounce my last name correctly. Second of all, Mr. Gonzalez did not confer with me before filing the motion for continuance. It was filed on Friday. I had no communication from him before then. My policy is always to grant continuances when it's based on any type of conflict that the opposing counsel has. The motion was not filed in conference with us. Second of all, it simply said Mr. Olivas was out of town. I'm out of town. Mr. Llarena is out of town. And this was a motions hearing. There's no evidence that was going to be presented. So when your court coordinator called me and asked my position, I said, I don't think there's a basis for this motion for continuance.
Right. She didn't communicate with me other than to say she opposed it.
I have not received any responses from you, Mr. Gonzalez. If you've
Well,
sent me,
I know, but you're complaining about those things, and yet you won't give me the courtesy. And then you file motions and you complain that I'm not communicating with you. I mean, this is a two-way street. And I've never, at least that I can recall in 30 years, ignored an attorney asking for a motion for continuance, ever.
I'm sorry, I didn't realize there was a motion for continuance pending, but proper time to bring that up would have been right before we started the hearing. I've already ruled. Is there an issue in regard to the discovery, Mr. Gonzalez? Are you concerned about the days that you'd have to respond to that as opposed to
Correct.
discovery? Yes?
Correct, Judge. I have to meet with my client. My client's out of town. And so that'll have to take place. And then I need to meet with him so that we can figure out what's a good date to go take the depositions or have the deposition done electronically.
That's something, okay, what I thought maybe you were, is just generally do 30 days from the date it's given. So if I approve this today, you'd have 30 days to provide this, what she's requesting. Is that where you have an issue?
Correct.
Okay, and what are you wanting?
Well, Your Honor, I would think that I would at least need 45 days. I won't be seeing my client for more than a couple of weeks. And then I don't know whether this file is kept here or in one of the other offices down district. I'm imagining it's here, but I don't know that for a fact. And I don't want to have to be running around at the last minute trying to figure out, what other argument or what other document rather would fit within the scope of what she's asking for.
Okay, Ms. Balovich?
I asked for just the contracts. So under the occupations code, bail bonds people are required to keep a file of all of their bail bonds. So he just has to have a file, and that would have all the contracts in it. If he needs time to produce it, that's fine. We don't have any settings in this case.
Okay, so we'll go 45 days. Okay. Anything else?
I would just ask that the parties confer with each other before filing motions with the court. You can see from the record, I did communicate with Mr. Gonzalez before I filed the motion for expedited discovery. He failed to communicate with me before filing the motion for continuance. I'm happy to communicate with Mr. Gonzalez directly. He's made no attempts to do so.
Your Honor, I think I don't need to confer whether to file a motion for discovery. And I think that would be, asking us to do extra work.
I think that's untrue, Your Honor. JP Court discovery is limited. And
Right.
Before I filed my motion for expedited discovery, I attempt to resolve it without court intervention.
Okay, I'm conferring with you now. I want to take your client's deposition
I don't have enough information to know why you need to do that. We can confer.
because I need to depose her and find out. I need to know all the facts concerning this contract from her point of view. So I do need to depose her. I'm conferring. I'll file a motion.
Okay, well, I would urge you all to confer as best you can. If not, just set a motion and we'll hear it in court. Anything else?
Nothing for me, Judge.
Ms. Palovich?
No, Your Honor, other than I expect that I will get the contracts before you try to file a motion for discovery, since you're going to obviously be able to communicate with your client before.
No, I don't think I think I can file my motion for discovery probably in the next couple of days.
Okay.
Then-
Okay. So, Ms. Palovich, so you're
Your Honor, the basis of this motion for expedited discovery is his client is claiming that my client is going to have to pay additional attorney's fees because of a contract that she signed. We need to be able to see that contract before he continues this litigation.
Well, wait a minute. There's no rule that says that. There's no rule that says that.
He's making an assertion in a demand letter to my client instructing me to drop our claims. And that's attached, that's his own letter is attached to that motion for expedited discovery.
There's nothing that requires me to give you any documents before I set a deposition. That just doesn't exist, Ms. Blagovich.
That's correct. That's why I'm asking the judge to order you to produce that.
And I'm
contract.
asking the court not to do that. But now we've gotten to the heights of ridiculousness. She wants us to show anything that's in our hand, but then she's going to come and fight about having her client be deposed. In her pleading, she's saying, "Oh, we didn't understand. We signed. We don't even know
okay.
the language."
I'm going to grant the motion, the order for the expedited discovery. We're now on May 4th. So this would be due. So June is due on or before June 11th. If you have discovery, Mr. Gonzalez, I'd request that you confer with Mrs. Palovich. If you all can't discuss them, set a hearing, and then I will consider the timelines of that requested for discovery at that point in time. Okay.
I'll file it, Judge. I'll be filing.
Okay.
Thank you, Your Honor.
Thank you all.
May I be excused?
Yes, thank you. I'm in the meeting.
Thanks, Judge.